Hello, my name is Daniel Decker, and I'm a member of the Salish and Kootenai tribes here on the Flathead Indian Reservation, and at this time we are filming here. My background is both as legal counsel for the tribes and tribal corporations, currently working for the tribal corporation known as Energy Keepers Incorporated. In my past, I have managed the tribe's legal department. I graduated from the University of Montana Law School in 1982, so I've been doing the legal game for a while. I'm also a rancher, and I've been owned and operated my own ranch now since about 1986. So I've been doing that for a while. But at any rate, what I was asked to do, and as I term it, to tell a story. And the story that I'm telling, or to share with you, is a story of tribal sovereignty. And the goal with this video is to help people, and in this case, young adults, high school students, middle school students, understand why our tribal community and homeland is the way it is today. And part of that, to get to that, I should say, from my perspective, you need to tell a story that includes the timeline of how we got here. But backing up again, I think it's really a tale of tribal sovereignty. It's a story how the people of the Confederated Salish and Kootenai tribes have exercised that sovereignty, their right to govern themselves, their territory, their people, for the benefit of their people, for the general welfare and safety and economic well-being of their people. A part of tribal sovereignty isn't just the governing, but it's the right to perpetuate who we are. It's the right to preserve our identity. Our identity is molded in the ground that we're upon. It's molded in the areas that we have lived, and it is really embedded in our life, our society, our culture, our language, our songs, and how we live today. We live our lives, most people view us as being basically contemporary with all the other peoples of the United States, for example. But what they don't see are the little things in our lives that we do differently. But part of exercising sovereignty is to guarantee that we have the right to do that. The story begins from my perspective, and as I back up, the story is about how we have taken care of ourselves, that we have lived here for eons, that this is where we're from. And when we look around our reservation community in our lives, we've got blood in the game, not skin in the game. We've got blood in the game to make sure that our future generations, and you hear it a lot, but how 7 generations from now will still be able to live a native lifestyle, an indigenous lifestyle, here where we now exist with many other people. It's about having our homeland and how we protect this homeland and what the tribes have done over the years to do that. When we talk about reservation life, the beginning of reservation life really started in 1855 with the Treaty of Hellgate. And you have studied this treaty, you've read this treaty, and you understand that the treaty in the beginning was a contract. It was a land document. We gave up land in exchange for a permanent tribal homeland where we were to have the exclusive use of that homeland forever. That was the bargain. The bargain also included for part of the tribes that they could remain in the Bitterroot Valley on what was called the Lolo Reservation. But that portion of the treaty was never upheld. It wasn't kept. Like so many other treaty stories, it wasn't kept. The short journey of that story is that by 1872, they were essentially treatying with the Bitterroot Salish for their removal. And by 1891, without going through all the politics of the time, those remaining Salish in the Bitterroot were removed to the Jocko Reservation, which today we call the Flathead Indian Reservation. And so in October of 1891, and I actually think it was like October 15th, I may be wrong on that date, but in the middle of October in 1891, the Salish were brought together in the Bitterroot Valley and brought north to the Flathead Indian Reservation. Forward. So by 1892, essentially you have all the Indians on the reservation. They were still exercising their rights to fish and hunt, which included both on the reservation and off the reservation. They continued to live a subsistence lifestyle, but many families, and most families, by 1890 had gardens, had their own livestock. They had horses. They were taking care of their livestock and horses and living a lifestyle which was a good lifestyle for the time. They were living pretty much as well as most people in Montana by 1890, by 1900. But to some degree, it was too good because people became jealous of where we live today. You drive around this reservation, it is gorgeous. The Creator gave us grand mountains for the sun to rise over. It gave us grand mountains to the west for our sunsets, and a beautiful lake to the north. Everybody recognized where we live. And it has been said that if it weren't for Flathead Lake, we wouldn't have so many jurisdictional problems, which is probably true, because people wanted to live around Flathead Lake. But at the time they couldn't, because we had this land, the Flathead Reservation, for our exclusive use and benefit. That was the treaty, to the exclusion of others except for rights to, I shouldn't say trespass, but rights of ingress and egress to travel across the reservation if necessary. But there was that. But it was such a nice place that the Bitterroot Valley is getting full of squatters. Now the new squatters are coming in, and the people who were squatted in the Bitterroot Valley didn't want any more people there, just like the Salish didn't want more people there. The new squatters down there didn't want more people. Where did they go? They go north. So the Salish and Kootenai people would not accept what the government argued were the benefits of the Allotment Act, did not want to do that. That they were perfectly content with the lifestyle of sharing the land that had been provided. So the government, because the tribes wouldn't accept this 1887 piece of legislation, said, well, the Salish and Kootenai people are very special. They better have their own allotment acts. So in 1904, they passed the Flathead Indian Allotment Act. Now, this was an interesting time because when that happened, and while this was going on, the goal, however, was once all of the individual Indians had been counted and given a parcel of land, if there were lands left over, then the federal government, by the terms of this legislation, could declare that land left over surplus and open that up for entry to non-Indians, basically homesteading to non-Indians. So in 1910, the government, by proclamation, opened this reservation to homesteading by non-Indians. And that accounts for part of how our reservation looks today. There are a lot of non-Indians living on this reservation. That started in 1910 with homesteading. So, and again, a violation of the treaty. However, that happened, but in the meantime, some interesting things were going on that have a significance with how we live our lives today. In 1905, what I didn't mention was the treaty we entered into is what's called a Stevens Treaty. And Isaac Stevens came through and he entered into treaties all across the Northwest for the purpose of gaining government title to land so that a railroad could be built to the West Coast. But under his treaty, he created essentially what today we refer to as a boilerplate language in the treaty that he entered into with tribes as he went west. And the Yakimas are one of those tribes west of us that have a Stevens Treaty. In 1905, a Yakima Indian, or actually Indians, were trying to fish in their traditional places, and as you've read the treaty, Article 3 is can fish in usual and accustomed places. And so they were going to the accustomed place to harvest salmon, and there were private landowners trying to keep them from getting to the river to do that. And they were declaring them in trespass, that they were violating state law, that they weren't abiding by state regulations. But their treaty gave them that right. The U.S. Supreme Court agreed with the Yakimas that if they had a right to fish in the usual and accustomed places, they had an encumbrance upon the land that gave them an easement to go and exercise that right of fishing. So that was important because we have a Stevens Treaty, and this was the U.S. Supreme Court upholding that right to off-reservation activity. Then in 1908, in north central Montana, we have the Winters case. And the Winters case used much of the language that the Supreme Court used. And again, it's the Supreme Court. The Winters case is from the Fort Belknap Indian Reservation. And what was going on were non-Indians were diverting water out of the Milk River before it got to the reservation. The government got involved to say, no, you can't do that. But the Winters case, using much of the language from the 1904 case, came up with the principles of federal reserved rights for Indian reservations. What I didn't talk about earlier, because you've studied the treaty, is that reservations tended to be created for a purpose. The main purpose was a permanent tribal homeland. Well, the Fort Belknap Indian Reservation, they were in a treaty in 1868, and then later their boundaries got changed. But the court held that the federal government created the new reservation with its boundaries by an act of Congress, and that they were guaranteed that land as a permanent tribal homeland, and that there had to be sufficient water for the purposes of that reservation. And part of the purposes of the Fort Belknap Reservation were agricultural. So the Winters case stood for the proposition that that reservation was entitled to water for the members that lived there, for the tribes that occupied that reservation, for the purposes of that reservation, which included agrarian purposes. So it started what people referred to then as federal reserved rights. And most people then at the time looked at it like it was tribal, it was federal reserved rights reserved for the benefit of Indians. And we'll come back to that language later because there's additional language, but in terms of the purpose of the Winters Doctrine is the first water case. So we talked briefly about 1910, but you see in that short era a lot happened. And with the Flathead Indian Allotment Act came one of the major things in our lives today is the Flathead Indian Irrigation Project. And we could talk a lot about that. I could go down that line, but it's an important part of our life that we don't think about. It has 12 major reservoirs, most of which are on tribal land, 20,000 miles of canals and laterals and ditches as a part of the project to serve irrigators. But that was all part of this. And today it's so present we don't even think about it. We go by Nine Pipes Reservoir. It's an irrigation reservoir. We go by it all the time. We don't think of it. Part of the irrigation system. People think about it. Many tribal members think about it because it's a good place to go fish for bass. Exercise our fishing rights. But it has that presence today, and that reservoir was built as a result of the irrigation project. It wasn't naturally there. There were ponds there. As we move from 1910 and we move forward, I'm going to kind of leap ahead here, because then in the 20s, the BIA was an ever-present body, and with the development of the irrigation project, while they were doing the irrigation project, the federal government also created an electric utility to serve the reservation. So the Flathead Irrigation Project had an irrigation division and an electric division. So we as we turn on the lights today, the beginnings of the utilities that allows us to turn on our lights today is known as Mission Valley Power, but it started back in the teens, the 19s, over 100 years ago, as an electric distribution system. And it serves everyone, not just Indians. It serves everyone, even though it was a Bureau of Indian Affairs electric utility. So as a part of that, in a combination with the electric utility and with the irrigation project, it was conceived that there should be some hydroelectric turbines created in the rapids below Flathead Lake, roughly about 5 miles below. And there was a natural rock feature that would allow for, and it was shaped like an arm into the river. So you had this bend in the river. It was like an arm. And the idea was to drill a tunnel through that rock arm and put hydroelectric generators in there. And the idea was to generate electricity for the utility and for the irrigators, so that they could pump water out of the river above that into the irrigation project. That was then. By 1930, however, many energy companies of the time in electricity seen the benefits of what it could truly be, rather than the smaller generation system that the government had thought of, but a much bigger one. And at the time, the project they conceived became to be known as Kerr Dam. And in 1930, that hydroelectric project got its first federal license under the Federal Power Act to own and operate that hydroelectric facility. The hydroelectric facility was built entirely on tribal land, using Flathead Lake as for storage of water, and the river system, of course, for running the generators. However, that was the first license in Kerr Dam, and at the time, it expanded a bit over time. But so what we know today as SKQ projects, it was at that time called Kerr Dam, and in 1930, and then we went through issues because it went from the Rocky Mountain Power Company to the Montana Power Company, and then the Montana Power Company it was licensed to operate from 1930 to 1980. And I'll come back to that a bit. But with that, what people don't realize is that dam is not a reservoir. What that dam is a headgate on the lake. I'm trying to describe it as simply as I can. Because when the dam, it's called a dam, but it uses the natural features of the lake. So it only stores water as high as what the natural high water line of the lake is. That's what it does. And what it does is controls how fast the water leaves the lake. That's really what it does. And it has to be managed, of course, in terms of the system of water coming in and water going out. And initially, Montana Power Company operated it on what we called a peaking facility. So they would ramp the rates up and run a lot of water through the turbine when they needed air conditioning in Seattle and Portland. Or they would really run the water through the turbines when they got cold in Oregon and Northern California and Washington. That goes back to that era of time. However, even after that started, though, the tribes had to argue for the benefits of using tribal land. And there was a portion of the Federal Power Act that said that when federal lands were used by a private company, that private company had to compensate for use of those, quote, public lands, which also included tribal lands. So all through the course of that first license, there were battles all the time over what was the appropriate rental amount that the tribes should receive for having this fantastic facility on tribal land. One of the first things that happened, though, was a debate about how much were the tribes entitled to, and part of the battle with Montana Power was, going clear back to 1942, Montana Power versus Rochester, it was who owns the south half of Flathead Lake. So in 1942, the tribes for the first time were part of litigation that proved by the language in our treaty, and what was key was that the boundaries in our treaty were described as the southern half of Flathead Lake. And by calling that line the southern half of Flathead Lake, the courts interpreted that to surely mean that it was intended to convey the beds and banks of the lake along with the treaty. So, in that case was the first time the tribes had to be part of a litigation to prove that the tribes owned what they treated for. As we move forward, and then when we got into the 50s and 60s, it was said if there was no water, there would be no Indians, because by then we had all this case law, the Supreme Court decision saying we owned water. We're entitled to water. So the federal government in 1952 passed what was known as the McCarran Act, and through some legislation called the Colorado River Conservation District, the federal government was, what the McCarran Act did was, governments have sovereign immunity. And what they did by that act was they waived the federal government's sovereign immunity for federal reservation of water rights to be litigated in state court. And most people think about it in the sense of Forest Service land, Bureau of Land Management lands, National Park Service lands, but it was interpreted in the Colorado River case to include Indian tribes. It didn't waive the sovereign immunity of those tribes, but it waived the sovereign immunity of our trustee. And so they had jurisdiction over our trustee. And then if we go back to the Winters case, it was a federal reserved water right for the benefit of Indians. So the trustee, our wonderful trustee then, was brought into the litigation, and tribes later objected, but the court said no. Because of the McCarran Amendment, there was jurisdiction over the federal government as your trustee to litigate your water that they held on behalf of you. So subsequent to that, it became pretty clear that if tribes wanted positive rulings for themselves on water, they better get their act together and they better get in court, because we learned early on, when you go back to our removal in the Bitterroot, you can't trust those federal government officials. So you need to do, if you can't trust them, you better do a better job than them and do it for yourself. And so we begin to start an interesting time frame for our reservation here, because then in 1954, as I jump forward, and this is kind of 50s era, jurisdiction, and with the jurisdiction in 1954 we had a dispute on the reservation here, because Montana was exercising jurisdiction over non-Indians on the reservation, but Montana, more than that, was acting like the water resources and fishery resources were theirs, that they could manage that. So the story is that they planted some antelope in the center of the reservation, what we call the river country, along the Salish Mountains there, that they planted antelope in that area. Well, you know, we're subsistence people, right? And so we have tribal members go out hunting and they go, whoa, antelope. So they stop, they go hunting, they catch up with the antelope, they take a couple antelope. Well, the state of Montana does not like this. They say those are state antelope because they planted them on the reservation, and they cited these two tribal members. Well, the end of that decision was, and the Montana Supreme Court agreed with it, and even the McClure case went back to using what the Winans case that we talked about way earlier in the early 1900s, and said, you know, by treaty they guaranteed to themselves the exclusive right of taking fish on the reservation. So, okay, you might have put them there, but you, the state, cannot prosecute them. So you might not like them shooting your antelope, but you don't have the jurisdiction to prosecute them, and that hunting case ended up being dismissed, but it really stood for the proposition the state did not have authority to regulate the hunting and fishing activities of us on our own reservation. Now, the state still stayed active in all of this, but that, you know, kind of pushed things along, because then when Public Law 280 came around, the state wanted that kind of authority. So In 1963, at the urging of the state of Montana, lobbying the tribes hard, they got the tribes here to agree to share that jurisdiction over tribal members with them. But one of the things that did, though, is it specifically excluded hunting and fishing. The tribe said, we're not falling into that trap. You're not going to be regulating our tribal members fishing and hunting. So Public Law 80 specifically did not include it. It included misdemeanor jurisdiction like traffic stuff, assaults, all of that. But then that took the felony jurisdiction away from the federal government and gave it to the state. So we had that change. Now with this, the federal government, of course, was pushing this along as well, because it took the onus or the burden of that responsibility from them and put it on the state of Montana. So that started what all of us back in the day called concurrent jurisdiction, which meant, for example, with a tribal member that has a misdemeanor, he gets in a bar fight. He or she gets in a bar fight. It's a misdemeanor assault case. In that case, the tribe would have jurisdiction and the county would have jurisdiction. So it was shared jurisdiction over Indian people. So, but it wasn't shared to the extent that the tribe had jurisdiction over non-Indians. It was only shared to the extent that those non-Indian government bodies that they were seen at the time had jurisdiction over indigenous people, not the other way around. So we're going along, and as you can see, things are changing. You now have the state, in many ways, into Indian business because of Public Law 280. And it was really short into it. It was like within 3 years of it, many tribal members did not like it and wanted out of it. So there was political pressure to do that, but it didn't happen. It still stayed there. And I could tell war stories about that, but I won't get into that right now. But the other thing was the state with that foot of jurisdiction, and as I talked about a story of sovereignty, it's if you don't use that sovereign muscle, it'll go to waste. If you don't lift weights, you'll lose your biceps, that kind of thing. So it's a sovereignty. If you don't exercise it, you lose it. It's not one of those things. If you don't use your authority, somebody will step in and exercise it instead of you. And in this case, the state of Montana was all too happy to exercise that authority in place of the tribe. So it allowed them a foot into the door of controlling Indian people. So in the 60s and in the late 70s, Indians started having smoke shops pop up all around the Northwest, all around the country. And you go, what's a smoke shop? Well, everybody smoked back then. And Indians could sell untaxed cigarettes to individuals because the state couldn't tax them. And, of course, this good old state of Montana did not like that. And they challenged the tribes on it. So with Public Law 280, the state was into Indian business. And one of the things that was going on, it was a time when everybody smoked. And cigarettes were big business, and Indian tribes, because the states couldn't tax the cigarettes that tribes had, or that individual Indians sold, smoke shops cropped up. And the state of Montana didn't like it. They started a lawsuit, and it came to be known as Moe versus the Confederated Tribes. It's a U.S. Supreme Court case. It came down upholding the right of tribes, or maybe I should say the right of tribes to sell cigarettes without state tax, but more it rejected the state's attempt to tax Indians. That's really what it did. It said, you, state of Montana, can't tax Indians' business. You can't tax those cigarettes that they sell. You can't make them get a state license to do it. You can't do that. The other part of it went a bit farther, though, because it went to say you cannot tax Indians' personal property. And so today we don't think about it, but when we go to license our vehicles and register our vehicles, they cannot tax our vehicles. They cannot tax the value of the vehicles. We go and get license plates because of tribal law that says it's to public safety benefit to have all the vehicles registered. And that makes sense. There's a public purpose for that. So we have to pay to have our vehicles registered. And it really helps for public health, public safety mostly, and so that you know the vehicles that are out there, you know they're insured. They have to be insured to get them registered. So, but Mo said can't tax the sales of cigarettes and personal property. But farther than that, when you can't tax those things, it then goes to include you can't attempt to attack income made by Indians on reservations. So when you have a job on the reservation and you're a tribal member from here, you have to pay federal tax, but you don't have to pay state tax. The state does not have a right to tax it. This decision, however, has come to create some things that tribal members really don't think about. So when we go to the gas pump now, we pay exactly what everybody else pays at the gas pump, but the state doesn't have a right to tax the gas that we as Indians buy. So recognizing that, there's been an administrative system created that estimates tribal member consumption of fuels. And we have an ordinance that goes to that makes it sound like a tribal tax on those fuels. The states collect it and they rebate those taxes collected to the tribal government. On cigarettes they do that, and on gas fuel taxes they do that. So Mo has created a system out there. The results of it have created this system whereby the states kind of like it because it doesn't look like we're getting cigarettes cheaper because there's now a quota system, but people are smoking less than they used to. So it's kind of changed that way. But the principles that they can't tax our personal property, can't tax our mobile homes, can't tax our trailers, our livestock trailers, any personal property that we might own, they can't tax where they would tax non-Indians for that property. And as I was saying, we get into this time, so that was in 76, and lo and behold, it comes along that in 1977, right after this case, Montana finds a tribal member hunting off the reservation to the west, just to the west of the reservation, out of season as far as the state was concerned. They caught this individual with a couple of deer, and they cited him for violations of state law for hunting out of season. The individual was hunting on Forest Service land. That goes to court. The court says, nope, state of Montana, you can't regulate this guy when he's exercising his treaty rights in accordance with the terms of the treaty. And the court determined that open and unclaimed land, which is the language in our treaty, usual and accustomed places with the privilege of hunting on open and unclaimed land, that open and unclaimed land included federal lands like Forest Service lands. So federal lands were considered to be open and unclaimed. That definition gets kind of refined over time, but once again, Montana had to be told that they didn't have the right to regulate that. But what it did do then is it did give tribal government kind of a wake-up call. They were monitoring what was going on off the reservation, but it then really made sense for the tribes to include in their hunting fishing regulations that covered tribal members hunting off the reservation. So even though they're off the reservation, they're still under the jurisdiction of the tribe if they're exercising a treaty right. So if you're fishing off the reservation in the usual and accustomed places, you're exercising that as a privilege of the members of the tribe, and that privilege gets regulated by the tribal government. We have this explosion of population on the lake. And in 1980, it started in the 70s with a marina owner in Polson, Montana, who tried to modify the beds of the lake and built these water wharfs and large dock structure and stuff out into the lake. And the tribe in the meantime had passed what we refer to as the Shoreline Protection Ordinance to regulate the construction of structures on the beds and banks of the lake that we've already proven we owned. So, and the court cases actually started a little bit earlier, but by 1982, in what is referred to as the Naaman case, it was proved once again that we, the tribes, own the south half of the lake. And what the court really did was recognize that even though they were riparian landowners to the lake, that they owned property that could be considered shoreline, the tribes owned up to the high water line of the lake. And that where they were building docks was in fact tribal land. And if there's anything that the tribe should have the right to regulate, it's the use of their land. And so Naaman came down in favor of the tribes, the right to regulate non-Indians, and of course they were arguing that, but because they were using tribal lands, the court said yes, they do. I was mentioning as we move forward here, you have the irrigation project that's an ever-present body on the reservation. You think about the size of it, it's one of the largest irrigation projects in the West. And it was originally conceived and designed for the benefit of Indians, but within a couple of years it was amended to allow non-Indian beneficiaries who bought what were formerly individual Indian lands and lands that were homesteaded, that because of the opening of the reservation, to be included as a part of the project. So we have the projects here, and once again going back, it was a Bureau of Indian Affairs project on the reservation. And the 70s and 80s, there's kind of an explosion of things that the tribes do. And I'm calling it an explosion because the tribes became very environmentally minded. And not that they became more environmentally minded, but the tribes began to recognize that there were tools that the tribes could use to protect the tribal homeland. But going back to this irrigation project thing, in the early 80s, because of our fisheries and wildlife program was a part of it, but the BIA was drying up streams on the reservation, diverting water for irrigation purposes. And the principal stream that was involved in the litigation was the Jocko River, that by the time the Jocko River got into the Jocko Valley, it was a gravel bed, because all of the water was being diverted out for irrigation. And the tribes, no, this can't happen. So the tribes started actually fighting with the BIA to force the BIA to put water in the river. And as a part of that, the skirmishes, as I will call it, started in 1985. But as a result of those skirmishes, the tribes began to force the BIA to comply with their own regulation and force them to come up with an annual operating plan or annual management plan, irrigation management plan, to include minimum pools in all of their storage reservoirs and to include in-stream flows in all of the streams, because otherwise they were in violation of the treaty, because we had the exclusive right of taking fish, and you can't take them. The fish can't live. We don't have those walking African fish here. They just don't get up and walk to the next body of water. You dry them up, they die. So on that basis, and we argued irreparable harm, the irrigation project then finally, but we had to sue our trustee to make it happen. So as that started, then the BIA started these management plans. But as soon as the BIA started a management plan that included in-stream flows and minimum pools, the non-Indians who were part of the irrigation project said, no, we can't do that. Our crops and our cows are worth more than those fish. We can't do that. You're an irrigation project. You shouldn't be allowing in-stream flows. You shouldn't be making minimum pools. And so the Joint Board of Control, as it was called, the irrigators, sued the United States over their BIA management plan. The tribes joined the litigation, and in the initial part of the case, the Montana Federal District Court granted a partial injunction to the irrigators, saying that there had to be just and equal distribution of the water. Well, if you know water rights, that's not how Western water law works. So the tribes appealed and went to the Ninth Circuit Court, and the Ninth Circuit Court agreed with the tribes that if you have the right of taking fish, you have the right to have water to preserve those fish. And also, along with that, since the tribes were fishing, that right predates the creation of the reservation or the creation of the irrigation project, and been doing it since time immemorial, that those water rights to protect fish had a priority date of time immemorial, meaning we had a right to get water to fish before anybody else. And I'm going through this quickly, and if you understand water law, it might make sense. If you don't, maybe you need to go back and revisit that in terms of understanding water law. In Western water law, who uses the water first in time, is first in right to that quantity of water. So we were using the water for fish and wildlife, and since time immemorial, virtually nobody in Montana, even the irrigation project, could beat that, because the irrigation project wasn't built until 1906, 1908, and through the teens. So obviously we had the earliest priority date, and the Ninth Circuit remanded the case back, saying the tribes have a right to an in-stream flow, and they have a right to it, and the BIA can make that management plan and that determination of what is sufficient minimum pool and sufficient in-stream flow to the exclusion of the irrigators, because they have a prior right. So it created something that people take for granted now. I mean, Adair in Oregon was before us, but it's the same kind of principle, but they didn't have the same kind of issue of drying up the streams. And so, but in Montana, we definitely put a stake into the ground to say we have the right to protect our fishery resources. But when I go back then to this, what I call environmental regulation of the 70s and 80s, the tribes had created a recreational use permit system in the 60s. And that was kind of a headache, because everybody wanted to consider tribal land public land and not, why do we have to buy a permit from the tribe to use their land? And it took an education process to say that's private land, and we have the right to put up a no trespassing sign, and if you want to trespass, you need to buy a license to do that, or a permit to do that. But where I'm going with this is, and then I'll come back to fishing and hunting, but in that era, in the 70s, the tribes really started to think about management of our resources in a different way. The resource had been managed principally by the BIA. The timber resource was managed by a BIA by maximizing harvest. Cut down as many trees as you can. We had huge timber sales, sold hundreds of millions of feet of timber. And so it was timber sales, and it was leasing of land, and that's what the BIA was doing, and the membership was saying, we don't like clear cuts. We don't like this stuff. We want to protect our mountains. We want to protect the Mission Mountains. So environmental things started to happen. In 1979, for example, under the National Environmental Policy Act, NEPA, the tribes started an air quality program in 1979. And from that program, we became one of the first tribes in the country to declare Class 1 air quality or pristine air quality for the reservation. The tribes developed a water quality program and began to set standards for water quality. This started in the 70s, and in the 80s, we're doing this, but we're also regulating our wildlife. We're protecting the grizzly bears. We're protecting the female animals during the winter. We're regulating hunting harvest. Even though we were subsistence people still well into the 70s and 80s, we're doing that. We're protecting that. We're protecting the resources. As a part of that, then the tribes created an ordinance in 1986 that would regulate hunting and fishing on the reservation to the exclusion of Montana, that we were the exclusive authority to do that. And it immediately caused a conflict with the state because the tribes would not recognize state licenses and permits on the reservation. Somebody wanted to use our waterways, our lands, our lake, they better have a tribal license. Things went into a negotiation at that time, and as politics go, they always talk about tribal politics and, oh, you change the tribal council and everything goes south. Well, we had negotiated, because of this ordinance, the tribes had negotiated a fishing and hunting arrangement, a cooperative agreement, whereby it would be a unitary management of the reservation resources with the tribe as the lead in doing that. And so there was a hunting and fishing cooperative agreement. And there was a second one that went to the off-reservation as well. But in the meantime, Montana gets a new governor. The new governor does not sign those agreements that were negotiated by the prior body, by the prior administration. And of course, it was a changing of the hats of the good old party, right? So we went from a Democratic governor to a Republican governor. Republican governor doesn't sign, and we're getting close to regulation season. And so SKC-TV goes to court and asks for an injunction from the federal court to keep the state of Montana off the reservation, to say, we have the exclusive right to regulate, Montana has no business here. In 1990, the tribes got an injunction in the federal court telling the state of Montana they could not be on the lake. And the lake was the gem. The lake is the gem. The lake is a big amount of resource for fish, wildlife, and parks for the state of Montana. And when the federal government or the federal court told them, get off the lake, the governor, the new governor of Montana, did not want to sign, but his own administrators told him, not a good idea, Governor, because there's a federal court decision that says we can't be there, and the tribes are going to do it without us. And so we ended up with, at the time, a very favorable hunting and fishing agreement, whereby now on this reservation, you buy what we call a tribal license to recreate on the reservation, and you only buy a tribal license. And there's benefits to those living on the reservation. They get a break on the price. But the other thing that they get a break on is if they're a resident of the reservation and they buy a license here, they can use it anywhere in Montana. Montana gives it reciprocity. However, if someone is an off-reservation resident, a Missoula resident, for example, they have to buy a tribal license in addition to a state license. But what it did was it upheld the tribe's right to regulate hunting and fishing. While this is going on, the state of Montana is upset about a number of things, because while we had the cigarette tax case and we had these other cases going on, all of a sudden we get tribal members, principally, operating gaming operations with gaming machines. And the state was trying to shut them down, but once again, they never had the jurisdiction to shut them down. So without getting into the haranguing that was taking place, the best way to put it, the federal government, because this was happening all over, the federal government, the federal Congress, I should say, the Congress passed what is known as the Indian Gaming Regulatory Act in 1988. And that act set up a series of stages in the law of who had jurisdiction. But that's something that we don't even think about now. We've got 2 casinos here, probably, from my perspective, the nicest tribal casinos in Montana are on this reservation. We don't think about it, but that was a right that we had to fight for. We had to go to Congress with. We had to walk the halls of Congress. We had to lobby people. We had to even, in some cases, lobby against tribal neighbors because they were willing to maybe accept less. And we go to water, but I want to swing back a second for the bison range. So one of the huge things that's happened, we talked about in 1908 that it was created that They made the Indians sell their buffalo. Then they bought those buffalo back and put them on the reservation. But one of the things we had fought about the bison range for many years, saying that it should rightfully belong to the tribes. Now, the interesting thing, and maybe I can come back to that a little bit, is that now in 2022, after all of these years, 14 years later, we get the land back and we get the buffalo back. And it's ours. It now belongs to us. It's one of those things that I feel like the tribal membership has already taken for granted, that it was the federal government's, but we've been fighting for the last 20 years over the bison range, and now all of a sudden it's ours. And I've talked about this explosion in the 70s and 80s, and there's like these lines of things were going on all at the same time. So in the late 1960s and the early 70s, we had the Indian Self-Determination Act pass. And what it did was it created the opportunity for tribal governments to contract with the federal government, principally the Bureau of Indian Affairs or the Indian Health Service, to contract with the federal government to run those healthcare programs and those BIA programs for ourselves. And so Salish Kootenai tribes were one of the first in the country to start doing what was referred to as 638 contracting. And so we did that. And it fundamentally changed how services were provided to the membership. It fundamentally changed how those programs were operated on the reservation. And we moved forward. We had basically been a part of in and out of water litigation for probably 50 years, beginning in the 70s, for nearly 50 years, because with Montana's new constitution in 72, they quickly passed Montana Water Use Act and declared ownership of all the waters in Montana and declared that they had the right to adjudicate those rights. And because of the McCarran Amendment that we talked about earlier, it became 6 one, half a dozen the other, because they had jurisdiction over the federal government because of the McCarran Act. As our trustee over our federal, what rights of ours could be considered federal reserved water rights, i.e. the irrigation project, that they could have jurisdiction over the feds to measure that water, to quantify that water. So we, the tribes, basically did a limited waiver of our immunity to measure that water. It created a whole different era, and in most cases, there's been a water expert, and I agree with him. He was actually a hydrology engineer. He was an engineer and a hydrologist that I met in the course of my life. And we got to visiting, and he said, and I thought about it later, he was right. Water is a second treaty era for tribes. And most tribes dealing with water and measuring of their water rights have entered into what now is referred to tribal reserved water rights compacts. And those compacts, and the way you described it, I think was correct. And it fit the other statement I made earlier that was being said in the 60s. If there were no water, there'd be no Indians. Well, because Indians had water, we went through essentially a second negotiation, a second treaty process to protect our water. And so then we have the water compact. As a part of the compact, and why I also talk about it as a treaty, is that our water compact wasn't only about water. It was about the return of resources to the tribe. For example, the National Bison Range. It was about the right of tribes to gain back ownership of what are referred to as state sections on the reservation. So there's a process. And so while it's called the Water Compact, it did more than compact about water. It talked about land resources as well. And so I think that terminology of a water treaty is kind of correct. I would like to talk more about our tribal government and self-government. And I'd like to talk more, and one of the things I didn't mention, but it's a big thing too, is under the 638 contracting, The tribes now manage the BIA electric utility. It's called Mission Valley Power. We, the tribes, run it. It is one of the most efficiently run utilities in comparison to similar sized utilities that are normally considered rural co-ops. But it is very well ran. And it has been upgraded, and like anything else, it continually needs maintenance. And with the dam, when we got it, it needed maintenance. In addition to all of that other stuff, the company has put nearly $13 million into rehab and maintenance in the dam since we bought it. And we're continuing to do that. And within another year, we will have totally rehabbed all of those gates that are in the beautiful pictures when the water spills through the dam. We've had to rehab every one of those major gates. We have rehabbed all, by the end of this summer, we will have rebuilt all of those generators within the dam. And it should increase, under the technologies available today, probably 25 to 30 years increase the life of those existing generators. The interesting thing is the engineering of the time. It's amazing what a good job those engineers did, because of the tolerances and the very minimal tolerances that are allowed for that machinery to work properly. But we've rehabbed those generators. By the end of the summer, all those generators will have been rehabbed. It's like you buy a used pickup, if you're going to make it last, you got to basically rebuild it. And that's what's happened at the dam. It's basically all of those internal workings that could be rebuilt and overhauled, it will be done. And so not only making money, but rehabbing the facility and employing tribal members. We have tracks of employment where people are interested, internships. We've paid scholarships. We have educated tribal members. We've put them back to work. We have engineers, electrical engineers. But I wanted to talk about the dam because that's a success story. SNK Technologies is a success story. SNK Electronics is a success story. So we've been really lucky, but as tribal membership, this is how our life is today. So is there a lot to be done? Yes, there's a lot to be done. Is there improvement that could be done with our environmental programs? Certainly. Have I talked about all of the cases that we could have talked about? Not necessarily. But we had one of the cases I didn't talk about out of this environmental era was we had a case called Montana versus EPA. And the issue with that case was, as with air quality, the tribe worked with the EPA to have the ability to regulate water quality on the reservation. And as a part of it, that was objected to again by the irrigators and again by Montana, saying, no, if anybody's going to be doing it, it should be us, the state, or the feds. But the tribes went through the process to get qualified to operate the water quality program, and that had to once again go to court. But once again, the tribe's right to regulate water quality on this reservation within the confines of that and how it's allowed under federal law was upheld, I should say. It was approved by the EPA. It was the ordinances in place to do that, the regulations, all the public comment, all those things that come with that. Is the court said, oh, it's there, and the tribes have the right to set water quality standards to the exclusion of the state. So the tribes have been exercising the sovereignty. The story of sovereignty includes the businesses. It includes setting water quality standards, safe drinking water standards, health standards. You might not think about it, but if you go to the local tribal powwow, the vendors there have to pass tribal health inspection to be serving at the powwow. And if we don't think about it, it's just all part of what happens now. But recognize, as you travel the roads of the reservation, that In some cases, the roads that you're traveling on were probably built, maintained by tribal programs. That the officers that might pull you over if your tail light is out should be a tribal officer if you're a tribal member. But however, it might be a county officer if they're cross-deputized, but they can't cite you to county court. That has to go to state court. So we have all of these things that have just become a part of our lives, and we don't really think about them, but that's kind of the reality of today. Is the world that is out there today has largely been because of exercise of tribal sovereignty